Today's presenter, Russell Jackman, is a graduate of the McGeorge School of Law, University of Pacific, and was admitted to the State Bar of California in June of 1994. He has been vice chair of the California State Bar's Law Practice Management and Technology Committee and a member since 1996. He works specifically with law offices and attorneys that need to get the most out of their legal technology and creates PowerPoint presentations for opening statements, direct examinations, and closing statements to be used in court, and can work with attorneys directly to filter their documents and images so that they have the most powerful visual presentations possible. He also works with law offices and solo attorneys to upgrade their older systems to new ones, troubleshooting existing setups, and training attorneys and staff on Microsoft programs. He is available for remote access consulting on technology-related issues, so please feel free to contact him at any time.
Hello, my name is Russell Jackman, and we're here to talk about the California Privacy Act and what you need to know. And so I think the very first thing that we're going to talk about is exactly how did we get here, okay? Because this was all a part of a long-standing process. There were a lot of things that had to happen for the California Privacy Act to come into place. And the first thing that we really need to look at when we look at the history of how this all started is acknowledging first that data hacking is at an all-time high. And that a few years ago, we had some big problems with Equifax, with Yahoo, and even the Internal Revenue Service getting hacked. And a lot of people realized that there was a big problem, not only with the fact that these companies were getting hacked and that information was being leaked out to various criminals and who knows who. But the bigger problem was that the response from Equifax, Yahoo, these other entities was basically nothing. I mean, if you look back when you heard about all these different companies being hacked, except for the embarrassment that they had in the public, there was really no official governmental response. They may have been sued privately, and maybe you've gotten a notice in the mail saying that you're entitled to a $5 coupon or something like that based on a class action settlement. But that's about all that there really was maybe a few class action settlements, some slap on the wrist fines, and really, by and large, other than civil suits, nothing that was official was really organized as a response to it. And so in response to that, Europe noticed how lax the United States was on managing their data information. And they were also not pleased with seeing how the European response was to data hacks. So the European Economic Union, came up with the GDPR, that is the General Data Privacy Regulation. And that is a set of codes that say that if you have information that is based in Europe of European citizens, and we don't know where Brexit's going to land on all of this, but at least, for the main part of Europe, they started to treat the personal information of individuals as property and not as something that you can just public record and it's free to anybody to use whenever they feel like it. The traditional American response has always been, very few things are private and more things are public. And the European response has been, no, a lot more stuff really should be private, or at least you should have control over it versus it just being up for use to anyone to do whatever they want with it. And so we've also seen that the state of Vermont and soon other states are going to enact privacy laws. But the very first state in America to enact its own privacy law was Vermont. And Vermont is sort of the front leader of this because one of the main things is it's kind of a small state and it's a rather liberal state. So it was easier to implement something like this as opposed to, say, one of the larger states like California or Texas. But California was very quick to follow suit because California realizes that the management of data and the safety of data and the integrity of the data that's being shared is as important as the technology business itself. California relies on and thrives on, and that without some kind of a structured framework to allow people to give people the assurance that by using their data online that they'd have some protection from it, we couldn't provide that here in California, then a lot would be lost, and there'd be a lot of people maybe abandoning California because they wouldn't trust how their data was being used and dealt with. So that's been a very important element and major reason why California has enacted these data privacy laws. So another question that I sometimes get asked is, well, why isn't there a national data privacy act enacted the way that Europe did one for all of the countries of Europe? We right now are enacting individual privacy rights state by state, and that's not really a very ideal way to manage these sort of laws, because it's going to create a patchwork of state laws that are not going to be the same, although hopefully they'll be as compatible as possible. But when you think about 50 different state laws being enacted, or maybe even some states not even having privacy laws still, even after all this, it's going to make working across the country a much greater challenge than if we just had one national law. But, and I'm not trying to get too political on this, and I don't know how long this lecture will be staying online, but the current president that we have is not making this a priority at all about, dealing with these sort of privacy issues. And with the things that he's got going on in his background, he's going to probably not spend a lot of time working on that as opposed to other things that he's made a priority. So I think for now, California and the other states are just going to have to rely on their own laws, and hopefully they'll be compatible enough that we won't see major conflicts occurring between the two, between different states, and having to have federal government have to step in and favor one state over another. So that's going to be an interesting issue going forward. So we're seeing now that there are greater threats than ever before to get the information that you are trying to keep secret, such as viruses are getting much more complicated, much more threatening. They work even better in the background than most people realize, and they can get that information out at the speed of light to whoever wants to hack your machine. Phishing schemes are becoming very common too, and they're getting more sophisticated. We're seeing situations, and a lot of people say, well, those emails that are sent to me from my Nigerian prince, I'd never fall for that. And I understand that. But there are much more complicated and sophisticated phishing schemes being instituted currently. And some of them are even involving spoof emails. So they make it look like it's coming from a particular source when it's not that source. And things like UPS or Federal Express or even the IRS or Apple computers they can send you something that looks like it just comes from there, even complete with signatures and email address. Look exactly like the ones that come from the official companies, but they're not. And they're trying to tell you, oh, your sign-in attempt failed. You need to log back in. Or someone tried to hack your account. Please enter in the details of your account so we can verify it. They have lots of clever little schemes, and it's getting easier for different businesses to fall prey to these things without intending to. Just because you say, well, I'd never fall for that, maybe those are the ones from the past because they were so obvious. The newer ones are getting harder and harder to differentiate, keep yourself safe. Phone calls, you'd think that would be a simple way of, you'd never fall for a phone call, but I've seen businesses answer the phone, be told that, that's Apple Computer or IRS or iTunes or a different company or Amazon that's checking to verify information. And that's something they never do anyway, but businesses will, and law firms and individuals will give that information away and not realize that they're being hacked in a low-tech way, just as badly as if they'd gotten a virus. Upset employees are usually the other really big source of where this information gets leaked out. Someone that has a grudge against the company, someone that's upset about being fired or not getting a raise that they thought they were supposed to get or a promotion, they can leak that information out to hackers very easily and cause a lot of damage because they have all the keys on the inside. And sometimes businesses don't limit the amount of information that individuals have access to. So in other words, everybody that's on a network has administrative access just because it was easy enough to give that access to everyone. So these people can go into any files and get any information they want. And so if they want to hold the company hostage or just give that information out and just cause problems, it's easier for them to do than ever. Competition is another situation where you will see threats happening. So in other words, a rival law office or a rival company will throw these other companies to the wolves and sometimes even employ hackers or people that are from other companies to come in and try to break the security of their competition. And once that information is leaked out and the reputation has been spoiled, then the other company will stride in and say, hey, look at us. We've got a great safety record. No one's ever hacked us, but the people you're working with got totally hacked. And so that's something that can really hurt the reputation and cause business to go to other companies. And finally, and I hate to bring it up, but especially with the way things have gone since 2016, we understand that foreign companies and foreign countries have been working to subvert American computer safety. And sometimes, we can't say for sure, but there probably is some government sponsored hacking that goes on to control different entities and different companies. And there's nothing we can do to pinpoint it and control it. These people just pick up and disappear when we try to trace them down. So it's another interesting threat to understand that there may be foreign sponsored hacking that goes on too. And that makes stopping it even harder to do. So where do we come in on all this, and why does this affect law offices so much? Well, we've got a couple of legal rules that are really important to understand, and that when combined create a responsibility for us to manage this sort of data and privacy, not only for the clients, but for our own law offices. First one is Rule 3110, and failing to act competently. That is, a member shall not intentionally, recklessly, or repeatedly fail to perform legal services with competence. Okay? And for purposes of this rule, competence in any legal service means to apply the diligence, learning, and skill necessary for the performance of such service. And if a member does not have sufficient skill, then they can perform the services by associating, where appropriate, professionally consulting with another lawyer reasonably believed to be competent, or by acquiring sufficient learning skill before performance is required. And that's part of what you're doing right now, is acquiring the sufficient learning skill before your performance is required by tuning in on this talk and picking up what we're talking about today. And then confidential information for a client under Rule 1.6 is really dovetailing into the privacy acts and creating this sense of responsibility, again, not only for attorneys to their clients, but to attorneys to law offices and their own clients and their own profession. So a lawyer shall not reveal information protected from disclosure by Business and Professions Code section 6068 unless the client gives informed consent. To maintain and violate the confidence and at every peril to himself or herself to preserve the secrets of his or her client. The lawyer's duty is to preserve the confidentiality of client information that involves public policies of paramount importance. In other words, they are saying that your ability to guarantee the confidentiality of client information is one of the key elements of what makes law offices work. So lawyers are required to keep a client reasonably informed about significant developments regarding the representation. It's another element of it too. So not only do you have to keep a client's information protected, but you need to tell the client about how you're keeping it protected. And of course, if a breach happens, you're under a requirement to now inform the client about not only what breaches happen, what data is leaked out, but what you're going to do about fixing it and what you're going to do about catching the person or persons responsible and what you're going to do about providing protection in the future to make sure these violations don't happen. So these are greater responsibility than I think the previous impression was that the code made you do. And so I think that's one thing that attorneys are just becoming cognizant about and realizing that there's a tremendous responsibility for them to deal with. And then finally, the rule 1.4 communication with the client is that a lawyer shall promptly inform the client of any circumstance with respect to informed consent that's required and reasonably consult with the client by means to accomplish the objectives. Then keep the client reasonably informed on significant developments of representation. And finally, advise the client about any relevant limitation on the lawyer's conduct when the lawyer knows that the client expects assistance not permitted by the rules of conduct. So a lawyer shall explain the matter to the extent reasonably necessary. So in other words, you can't just wave your arms on it and go, I don't know, this is too high tech for me. It's all computer stuff and I don't get how it works. You're going to be managing your client's information through a computer system, and you need to know personally as a lawyer how that system works. You can't just say, I've got a guy, I've got an IT service, they handle it. Because without you being able to say at a moment's notice what the status is of your system, when was the last time you had a virus check? How often do you check for viruses? How often do you update? How often do you back up? How often do you encrypt? What kind of encryption do you have? These are big questions, and they're questions that are now being asked repeatedly when lawyers are trying to get their insurance set up or trying to get cybersecurity insurance. These are things that insurance companies are now asking, and they're asking with great detail as to what sort of protections are in place to make sure that privacy is being managed. So now that you know what the responsibilities are for attorneys, let's talk about what the California Privacy Act is actually all about. So we're talking about Civil Code Section 1798. Now keep in mind, this is a civil code and not a criminal code. So right now, there are no criminal penalties for violating the California Privacy Act. But as you'll see, the California Privacy Act has ways of making sure you comply with it, or it can get very expensive. Businesses must disclose what information they collect, what business purposes they do so for, and any third parties whom they share that information. Businesses are required to comply with official consumer requests to delete the data. Yes, that's one of the things that is an interesting dichotomy of where we're at with information right now, which is that we have both the need to save information forever so that we're not going to lose it. Once we take control of a client's data, we have to safeguard it and make sure that it's there, it doesn't get destroyed accidentally by hackers or by hardware malfunction. But the other side of it is that we now also have a responsibility to delete the data and make sure that someone is permanently removed from the system upon request. So it's both and so businesses that are required to comply with official consumer requests to delete that data need to understand that they need to find a way to delete all the data from all the different sources completely, including from backups, so that a person is completely out of the database. And when you talk about the multiple sources of where data is often stored, and it's no longer just on the office computer. With cloud systems, they can be all sorts of places. People can download the data to their individual cell phones or to thumb drives or to their email accounts, especially if they're able to access their personal email account from work. So tracing down exactly where all the copies of that data might actually be can be easier said than done. And this is why one of the things that I have always recommended is that companies do a data inventory and look across their business to see exactly who has data and where it's being located. And if things are being done outside the office, how is that being controlled? And if, for instance, an employee were to be terminated or quit, then what would you do about making sure that information is completely out of the access of that previous employee? So having a password changing policy, having an account closing policy, making sure that you have clients return all their hardware and that it's being erased and all of that stuff is really important. Having those things just go rogue and get lost once somebody leaves the company could be very costly now with the California Privacy Act. Consumers can opt out of their data being sold, and businesses can't retaliate by changing the price or level of service. That's very important too. Maybe not so much for law offices, but certainly for other clients. You're not allowed to then say, well, if you don't do this the way we want you to, then it's going to cost more, or you will not get the same service that you get if you give us your information and let us do whatever you want with it. Ironically, though, businesses can, however, offer financial incentives for being allowed to collect data. So coupons, money off for certain things, added services that you'll get because you're part of a data file exchange. Those things are allowed. And I think we'll get to a point where it's going to be some interesting arguments over where someone is, the difference between retaliation and a financial incentive. And we're going to have to see where the courts hold on that. And that's something I'm going to bring up later too, is that we don't have a lot of cases to work with. So right now, I can't tell you exactly where the law stands on these sort of things. We're going to have to either have more definitions come out. And that is another thing that we're seeing too with the California Privacy Act, is that while it was enacted in 2018, it was modified continuously through 2019 and really isn't going to have the teeth of enforcement until July of 2020. So even though it's been in place, it hasn't been enforced by the Attorney General, and they don't plan to until July. Now, that being said, I am talking on March 1st of 2020 or March 2nd of 2020, and July is only 4 months away. So time moves quicker than most people realize. And then finally, California authorities are empowered to fine companies for violations. So far, with the Vermont privacy law, there haven't been any successful challenges against the state of Vermont. There hasn't been anyone to say that it violates any kind of First or Fourth or 14th Amendment challenge. So they seem to be constitutional, and I wouldn't just wait to comply thinking, oh, well, government will just overturn this, when it gets challenged. It's better to be compliant first, and if they repeal the challenge, you could scale back on how much you're you're dealing with compliance. But in the end, I think you'll see that being compliant has a lot more value than fighting whether or not you should be compliant. So who is covered? Good question. That is, in the California Privacy Act, they talk about having a $25 million or more in annual revenue, or possessing more personal data than more than 50,000 consumers, households, or devices, or earning more than half of its annual revenue selling consumers' personal data. So a lot of folks will say, well, I don't make $25 million, so I don't have to worry about it. 50,000 pieces of personal data, 50,000 consumers or 50,000 individuals that you have, it's not that hard of a threshold to get beyond. I personally run a group called Linked Local Marin, and just with that group alone, I have 8,500 members in it. And I'm not even a really large scale business, but I'm almost 20% there just on a simple social group. And so you'd be surprised how quickly 50,000 numbers actually adds up. And then the other question is earning more than half of its annual revenue selling consumers' personal data. So I think not so much law offices, but certainly other companies need to look in, do an actual inventory and assessment of how much data they actually are selling and how much money they're making off of it. And does that actually comprise half their revenue? Again, some auditing is due for a lot of companies that just sort of been working automatically off of this, not really seeing how much money that they are making or not making based on the use of personal data. And then finally, and we'll talk about this later, which is that even if you are not necessarily part of these three levels, if you are actually considered a data processor, you'll also fall in under the act. And I'm going to talk about what makes people data processors, and it's a confusing level of law for a lot of people. So in that sense, again, it might not be such a bad idea to start looking at being compliant and suggesting that your clients get compliant and your law office get compliant, just for the sake of avoiding being brought in under law as a data processor. Plus, as I've seen with the GDPR, there are instances where entities will be considered like a subcontractor of a larger business. A large business will be covered under the GDPR, and then the GDPR authorities will issue a statement saying, well, if you need to show that your subcontractors have access to this data are also compliant, or you will be considered in violation. And then the big business will then go to the subcontractors and say, you know what, guys, we don't have time for this. You prove to us that you're compliant or you're fired. And so while they're not technically being brought in under the act, they sort of are, because their clients and their customers will be held under the Data Privacy Act, because the big company that they're giving that data to and sharing with the smaller companies is covered under the act. So, and the big companies have that responsibility because they are according to the GDPR, they're responsible for the acts of the subcontractor. If subcontractors have access to the data of a big company, then they pretty much have that back door. And if they are to the data of consumers, and if that data then gets compromised, if the subcontractor gets compromised, gets hacked, and that allows a hacker to then use the subcontractor's connection to the database to then access consumer information and then steal that data, modify it, do something corrupt with it, then you're back to square one, and the big company will then be held under the GDPR and most likely California Privacy Act for having violated it because they didn't control their subcontractors enough. And so big companies don't really have the time or the energy to police every single thing the subcontractors do. So they say, subcontractors, you prove to us how compliant you are. If we don't see how compliant you are and how proactive you are about being compliant, we don't want you as our subcontractor. So again, it has a way of trickling down or cascading down, however you wish to term it, so that you'll wind up being covered. And probably a lot more companies that don't think that they're covered under the Act wind up being covered under the Act based on this sort of additional layer of responsibility. So what data is covered? Well, talk about a laundry list. Now, I think the average person, if they were to think what data was covered, they would say, well, your name, your address, your phone number, credit card information, driver's license, social security number, and that's it. Well, we have a lot more here if you can see this laundry list, which does include social security number, account name, driver's license number, passport number, and other similar identifiers. But it also includes commercial information, records of personal property, products or services purchased, obtained or considered, other purchasing or consuming histories or tendencies. It also includes internet or other electronic network activity information, including but not limited to browsing history, search history, information regarding California's residents' interaction with an internet website application or advertisement. But it also contains geolocation data, biometric information, which can be things such as so it can even cover sounds. And in a very interesting clause that I saw that one client had put in on their privacy disclaimer, they even included smells. Yes, olfactory smell as an identifier. And maybe that's true. You know, if you too much aqua velva, you might, wind up on somebody's data privacy list. And then audio, electronic, visual, thermal, olfactory, there we go, for similar information. And then professional or employment related information. And finally, educational information. So a lot of these things were either considered maybe public information or maybe not protected information. It's hard to quantify where they would determine that this information actually falls under prior to the Act. So the Act now covers it, make sure that, it's part of what actually gets covered when the data is being assessed and what data is being revealed is being dealt with. So in other words, anything you're pretty much collecting from a client or that a client is collecting from a customer is going to probably wind up being data that should be covered under the Act and should be safeguarded at all costs. So one of the biggest questions that I've been getting recently, and that was because it just got enacted at the end of January of 2020, is the California Attorney General has enacted a subset of what is part of the privacy law. And that is establishing a class of what they call data brokers. And as this little chart shows you right here, 16% of consumers say they have significant or complete understanding of what information is being gathered. So that tells you like a good 84% have no idea what's going on. 20% of consumers have a significant or complete understanding of what data brokers do with acquired data. So that's another 80% of consumers have no idea what data brokers are all about. 71% of consumers believe it's important to be able to see and access collected information. 77% of consumers say it's important to be able to make changes to their data obtained by data brokers. But then 18% of consumers say they have a good grasp of what a data broker. So we're seeing like on both ends of the scale. First of all, there's about a 20% level people that understand what's going on. But there's about a 70 to 80% level of people that say that it's important to control their data, understand what's being done with their data. And then we're back to the 18% people that actually know what data brokers do. And then 80% of consumers saying they'd like to have a centralized website to manage their data, and 80% of consumers want to be able to opt out of selling or deleting acquired data. So it's on both ends of the spectrum, and they're both almost the same number when you look at the amount of people that want to have a data broker or want to know how to control what a data broker does, and yet there's the same 20% on that same side of people that don't know what data brokers actually do to be able to control them. And that's why the data broker idea was created and why they're starting to license these data brokers so that people know who they are and that they have this sort of control. And then the data broker law is there to control what they do. So let's ask the very difficult question of what is a data broker, okay? So Vermont started it, and then California added it with AB 1202, and then it was signed into law, as I said, and enacted in January, at the end of January 2020. So what it says is that when information is collected from a non-direct relationship, sold or provided to a third party that the consumer does not do business with, makes that person a data broker. And it also says that if you're selling that business, if you're selling that data from a client with someone that you don't normally do business with, that makes you a data broker as well. And so the lacking a direct relationship with a customer was hard to define. So what they did was they defined what is a direct relationship. And that is when the customer, client, subscriber, user, or registered user of the business's goods or services, or an employee, contractor, or agent of the business, or an investor in the business, or a donor to the business. But if the business is a data broker, they have to register and pay a fee to the California Attorney General. So going back to the direct relationship, if a business needs to contract with another business and give that data over in order to fulfill its job to the customer, to the client, that is not considered a data broker. So they made exceptions for things like mortgage brokers and banks and insurance companies that need to share information with a third party that the consumer did not contract with in order to be able to find a way to make their business work. But when you're just selling it for the sake of selling it, because you're going to make money off of it, there's nothing that's actually related to why you collected that information in the first place. So in other words, like I was talking with another person earlier about Evite and how Evite goes and collects this information from folks. They need to collect that information in order to be able to put these events together for people. But then they turn around and they sell that information to third parties, which does make them a data broker. They will then sell that information to party planners and to florists and to cake makers and to invitation design stationery printers. In other words, they will sell it to a third party to try to facilitate the event that you're trying to put on. But these are not people that you yourself have said, I want to find a party planner. I want to find a stationery store. I want to find a florist. Those are not things that you originally contract with when you go to Evite. But when you see ads that show up on the right side of your screen that are for florists and that are for party rentals, that are for stationery stores and that are for decorations and so forth. Well, those know about you based on the information that you have being sold out from Evite or whatever company to third parties so they can directly provide targeted advertising to you. It's not always onerous. The your data being sold out to third parties is not necessarily an evil thing all the time. And that's why you can disclaimer it. You can have people opt in or opt out of it, and you can have people be able to get incentives, financial incentives for doing it, because it's not necessarily an evil thing to get directed advertising on your screen based on you signing up with this service. And do keep in mind, of course, that to the end consumer, for most people, Evite is a free service, unless you're doing really large parties or charging money for the event or something. Most people can use Evite for free. But in doing so and using it for free, you give your permission to Evite to be able to sell that information out to other services. If you didn't give them that permission to do that, then they would probably say that you will not get the kind of access that you would get normally if you do. Again, not a punishment, but that they can't continue, they can't go with their goal of providing you with all the information you need if you won't let them give that information out to third parties. I know that's complicated, and it's certainly one thing that is going to make litigating the who is a data broker and people that don't believe that they're data brokers versus people that think they're data brokers and actually aren't is going to be probably a matter of litigation for a number of years. And considering the act was just put in place at the end of January and we've only had a month with it, it's unlikely that we're going to get an actual legal resolution to it right now, but it's probably coming down the line sometime, soon. So how do you comply? That's probably the best question of the entire talk. That is, you have to determine if your business falls under the CCPA. I gave you the guidelines before, and it's something that you can review with either your clients or even your own law office to see if you qualify for that. But even if the answer is no, do you wind up becoming a data broker anyway because of how you're managing your data if you're sending it off to third parties that the consumer is not aware of or the client is not aware of? CCPA is about clarity and transparency for clients and customers. That is one of the things that I think that a lot of people have issues with or questions about the CCPA. They say, why are they punishing us? Why are they making us the bad guy? It's not really that. It is the attempt, as we saw from the polling that was shown, that 80% of consumers need better clarity. They are asking for better clarity of how their information is being used. They are trying to find out how that information is being managed. And they don't want just somebody just throwing that information all over the place. They want to know that they've got control over it. The more that you can show clarity and transparency, the better off you are in like having to go through a CCPA audit. So is data being given to third parties and do your customers know about it? If they don't know about it, why don't they know? And can you make customers aware of that? Well, you really have to anyway. Find a way to do that that isn't going to upset them or make them think that something radically strange is going on with their information. You offer them a way to opt out of that information. Okay? Can they get themselves to leave? And is that disclaimer, is that opt out hidden on the fifth page of all this legalese, or is it something that's in a big banner that's right there on the first page someone can click on to get out of it? Can you explain in the materials, both in contracts and the websites, of how privacy is dealt with? It's great to have that information, and you really need it on the website, but having people, when they are signing contracts in person or online, to acknowledge what's being done with their information, and specific check boxes to say, I agree that my information can be sold or used with these third parties, goes a long way towards informed consent and proving to any authorities that you were able to make it a complete explanation as to how their data was being dealt with. And then you want to put privacy controls in place. Not enough to have technology sitting in a box. You have to actually put those controls on your website, in your databases, on your computers, and also that the people who are working with those computers and that kind of technology understand how that technology works. So there's the tech solutions, and then there's the contractual solution, which is the other side of things, which is that employees not only have to understand the technology and know how to protect the information, but they have to sign things saying they will respect this information. They won't be posting this stuff on social media. They won't be taking the information home on thumb drives or emailing it to their phone. Or if so, then they will be accountable for it, or you'll have a way of tracking that information if they are supposed to be doing that with their technology. So the more you can be ahead of the game, or your client can be ahead of the game and say, we have not only the tech solutions in place, we also have made sure that all of our employees, even our temp people, sign contracts that acknowledge they are not to take this information or share this information or leak this information out. They're not supposed to, expose any information to anyone else other than the client, and that they will also obey clients' requests to be deleted from the database. All may be put in place so that you can avoid any hassles with the California Privacy Act. So as I talked about, there are tech solutions that need to be thought about. And that is, you need to shore up your security. It's no longer acceptable to just shrug your shoulders and say, I've got an IT guy. You need to know, if you're running a business, how that works, how it's being maintained, how often security is being updated and taken care of. You need to use encryption whenever possible. It's sometimes hard to encrypt things that are going within office communications. It slow things down too much. When you're sending things outside to other clients, maybe from yourself to the client, or certainly from your client to third parties, and you're not aware of how secure their email system is, if you can take the time to email to encrypt your email and or the attachments that are being sent, it's probably more important to even make sure the attachment is encrypted. So for instance, locking your PDFs so that only a person with a password can open them, zipping files together, making that zip folder password accessible only, and then keeping a minimum of information available in an unencrypted email. So in other words, just say, dear client, attached is the information that you were expecting, and we have sent a letter, or we'll follow up with a phone call to let you know what the password is. So in other words, you don't send them an email with the encryption password in the email. That sort of defeats the purpose of the encryption, right? Because if someone breaks into the email, they'd have the encryption key that they need. But if you do it by phone, by fax, or in person, or by snail mail, then you've got a better assurance that this is being protected and can't be hacked. You want to limit access to client information. So you want to make sure that only the people that really need access to this information have access to that information. That you don't give temporary employees admin passwords, or just let them log in as yourself because they're temp employees, they'll be gone next week. You need to set up specific IDs for temp employees, and make sure that they not only don't have access to a lot of things, but when they leave the employment of the company, that their accounts are canceled. And it's always a good idea to, close up open accounts and people that have left the employment of the company as soon as you know that they're no longer getting any emails, or that you dealt with all the unfinished business with them, that you close their accounts and don't leave it open for anyone to access. And then don't use systems like laptops or phones in a public network without use of a VPN or a controlled private hotspot. You'd be surprised how easy it is, especially because most people, have their computers set on file sharing when they're at home or when they're at the office. That's something that's good to have. But then when they go on the road, they don't turn off that file sharing, and because it's a pain. Turn on file sharing, turn it off when you go, turn it back on when you come back, turn it back off. So a better way to deal with that is just not deal with public hotspots and dealing with Starbucks's free wireless network. If you are going to use a free wireless network, then please, I strongly suggest, and you're going to use a work laptop or a work phone, then use a VPN. The VPN software is relatively inexpensive. What that does is it creates what's called a virtual private network, or a tunnel that channels between you and your office computer and directly connects you right to the office computer as if you were sitting on the computer itself, or you're in a private network that just goes directly to the server you have at your office or with a client, as opposed to you getting onto a public network and having people possibly spy in on your network, because there's no way to protect public network on an uncontrolled non-private hotspot. And then we talk about contractual solutions. That's almost as important, as I talked about, as what we were doing with technology. Because if the people that you have aren't complying with it, the end user, the human, is not doing what you need doing, all the technology controls in the world aren't going to matter. You want to make sure that clients know what info is being shared, okay? As I said, clarity and transparency is very important. People know what's being shared and they agree to it up front. You don't have nearly as many problems. Then you want to give them the ability to opt out of any info sharing or sales. And you want to make that as easy and as clear as possible. As I said, don't bury it on page 5 of a huge privacy disclaimer thing where it's in 6-point font and done in gray coloring on a black background. In other words, you want to be able for people to say, I saw it there. I chose not to opt out because I wanted these certain features, or I saw it and I did opt out. And I thank you for being able to let me opt out of this and not being, subjected to having my information shared when I didn't want it to. Then collect only the info necessary. I dealt with a client once that was trying to say, oh, well, we want this, we want that, we want this, we want that, we want this, we want that. And I said, what are you going to do with that information? I said, oh, we don't know. We want it just in case. Well, grabbing and just hoarding information just in case is just going to lead a company or firm in trouble. You don't need it, and it's not important, then don't collect it, because it's just another piece of information you're held accountable for. And if it gets lost or stolen or corrupted, then it's just going to be a bigger headache. The less information that you have to ride herd over, it's just always going to be that way. The less information that you need to collect, then the less things you're going to be liable for and less headaches you're going to have. Employees have to keep the information private. So making them sign something that says that they are not going to be on social media while they're using your computer, that they're not going to download any third-party software without permission from the IT folks, that they're not going to install any apps without IT approval, that they understand that they're not allowed to share passwords outside of the office. They understand that there's going to be regular monitoring of their systems, and they're going to be audited, and when that audit's going to happen, and that what to do if the information is spilled out. How do they react? How are they going to make sure that the information is private? How are they going to notify clients that there has been a breach? That's all very important. And then you want to control who is given access to client information. So third parties that you are letting service your system, any technicians that work on your system. If you're going to be having your data managed by a third party, how much information are you going to give, and how much information are they going to allow others have access to when it's on their system is very important. So, it's not, again, up to just you controlling things for yourself. If you're giving that information to third parties, how are they going to manage that? And then finally, if you are indeed a data broker and you want to register with the Attorney General as soon as possible, fines can be up to $100 per day per incident, and those can add up quite a bit. Again, I don't know necessarily of anyone that's being held in violation of being licensed as a data broker. But for instance, Vermont, they were expecting about 1,200 data brokers to be registered, and about 100 of them have. So the fact that Vermont hasn't seen a lot of compliance will probably get California to start enforcing compliance on the data broker side pretty strongly. So you want to be ahead of that curve. And if you need to, I think it's only $100 to register right now as a data broker. And if you think you might be, it's probably cheaper to register as a data broker than to guess wrong and be held in violation of that law and be fined thousands of dollars. So why do you get a specialist? And the main reason is because right now we have new laws, but we don't have any precedent. I can't say that the Helding in case Smith versus Jones, we had this ruling, because it just came out and nobody has an idea of what is actually the ruling of these laws. So we're gonna see these laws get changed and modified significantly as time goes on. So, but we don't know how that's going to be. We really need to keep an eye on it. And then there's a lot of tricky pitfalls. So as I pointed out, there's the $100 a day fine. Could be civil action lodged by clients and consumers. You just don't want to necessarily fall into that. And then obviously you don't want to have to deal with the Attorney General. As I mentioned, the specialist is important because you need both a legal and a technical solution. It's not good enough to say, I've got an IT guy. That's not going to cut it. Or you say, well, we're a law firm. We have a bunch of lawyers. We got it handled. If you don't have both a technical solution and a legal solution, you don't have somebody that is accountable for the technological safeguards that are in place. You don't have someone that's accountable for all the legal solutions that are in place. That's a big problem. You need innovative solutions that won't be burdensome on clients and customers. So, and that's one thing that people are feeling out right now. You can't have the 20-page disclaimer, but you also can't put a disclaimer on a postage stamp. You have to find a way to make disclaimers easy enough and transparent enough that an average person can read it, not be lost in a sea of legalese. But you also can't leave anything out, because we notice people will say they didn't get informed consent if they didn't get the whole story. And then showing compliance is much better than doing nothing. GDPR, as an example, gives you time to comply versus just giving automatic fine. So when I've worked with the GDPR authorities in the past, they've looked at certain things and said, this isn't right, or this needs fixing, or this needs adjustment. They gave us time, several weeks, to adjust those things and get back to the GDPR and say, these are the things that we did to fix this. And then they either gave us a thumbs up or thumbs down. If they give us a thumbs down, they gave us more time to comply. What they don't want to see is someone blowing them off or not complying at all when they ask for compliance, for people to wave their hands and not respond and say, we don't care what you have to say, we're not complying, or we don't care, or we don't think we need to comply. So that's a harder situation to be in. Much better if you can just show that you are working on complying with the GDPR and or the California Privacy Act versus stonewalling. And finally, the Attorney General will start fining in July 2020. And I put that all in caps because I think, as are many of my clients, they waited for the GDPR to actually start getting enforced. I think a lot of folks in California are holding back and waiting to see what the Attorney General will start doing in July 2020. Now, keep in mind, those fines will go back to January when the Privacy Act was enacted and the Data Broker Act was enacted. So people think, well, fines will start in 2020. No, the fining will start in 2020, but the fines go all the way back to January, therefore costing you maybe thousands of dollars, or costing the client thousands of dollars if they find out that they haven't been compliant. So how can Computer help? And that's, I can do things like putting encryption in place, shoring up computer security, putting systems to fight data leaks and intrusions, put contractual language in for employees and customers, and putting web page disclaimers and language to clarify to customers how the data is being used, help register with the Attorney General. But mostly being on top of laws and trends that will change and define the California Privacy Act as it gets enforced on a more regular basis. We don't know how this is all going to shake up, how enforceable it's going to be, how unwieldy or how practical it's going to be. And we're all going to have to sit back and wait to see what the end result is from all this. But I will say this, I only think that the California Privacy Act is going to be stronger and more enforced as time moves on, rather than people watering it down, because I think people really are aware that their privacy and the information they provide to companies should be more controlled. We saw that the statistics saying 80% of consumers want to have more control over their data. And that's a number that will probably, if anything, go up over time. And because of that, we're going to need to make sure that we take care of the information that is under our control and the information that's under our clients' control. So if you have any questions, this is my contact information. I'd really be appreciative if you gave me some feedback on this. And I really appreciate you folks for attending today's talk. Thank you very much and have a great day. Bye-bye.